Okay, so in terms of how you apply for a patent, um, applying for a patent involves preparing a patent application. And if you've ever seen a patent before, then pretty much everything that is in that patent was part of the patent application. And ultimately, once someone uh, submits the patent application and it gets reviewed by the patent office, and assuming it gets approved, then that patent application becomes the patent. So it's pretty involved of what goes into the patent application. It's pretty complicated. And that's why the process costs a good amount of money, is because there's a lot of work that goes into applying for a patent. And most of that work is, upfront in the beginning, in terms of, of putting in that patent application. So, um, I'm going to show you an example, actually. Let me show you an example of a patent. I have a question that was submitted ahead of time that I was going to answer in more detail a bit later, but let me just show you this patent that I have here. I'm going to share my screen. Okay. So this is a patent that I did a long time ago for an eyeglass um, locator system. And so this is what a patent looks like. I mean, this one, as you can see, it's got the patent number on top. It's got the date. It was issued in 1999. And just a brief description of what it is. And then there's some drawings that show eyeglass locator system. It's got a pair of eyeglasses, a transmitter that's on a keychain. It's got these earpieces that go over that could contain the receiver. And then there's text that describes in detail kind of what happened, or what was developed before this, kind of what our intention is, or how we're seeking to solve the problem. And then we go into detail about kind of what the solution is. And this is a pretty brief one. One of the reasons I pulled it is, as far as patents go, this is really pretty simple and brief. And then at the end of the patent, there are claims, and the claims define what it is that the inventor owns with this patent. So essentially, again, in order to apply for a patent, the first step is we need to, get a description like this together, get drawings like this together, and submit it to the patent office to be reviewed. And so when it gets to the patent examiner, what their review involves is two things. Is number one, they're looking to see if it's correct, in that there are a lot of rules about how patent applications need to be prepared and submitted. And the second part of it is that they're looking to see if it's different enough to be worthy of a patent. I mean, I think it's pretty plain to everyone that in order for something to be patentable, it needs to be different, right? You patent something because it's new, but it has to actually be different enough. And I often hear people talk about the different enough in terms of like, well, I hear that if it's 10% different, then it would be potentially patentable. But that notion of being 10% different or 20% different, I don't really know what I don't know what that means. Other patent attorneys don't know what that means, because that's not the standard. I mean, how do you make something 20% different? How do you know what 20% is versus 15 or 25% different? So that's not the standard. And again, the standard is what we were talking about before, non-obviousness. It has to be something which is not only new, but something which wouldn't be obvious to people in the field. So that's the kind of level at which the patent office examiner is reviewing it, is they're looking to see, like I said, does it fit all the rules of a patent application and how it needs to be prepared and submitted? And then also, is it something that's different enough or non-obvious so that it can be worthy of a patent? And if the application is reviewed favorably and the examiner looks at it and says, yeah, this is pretty good, this is pretty different, then it's quite, it's possible, it's likely that that the examiner will approve or allow the patent application. You get something called a notice of allowance, where the patent office says, okay, we've approved it, now you pay the issuance fees, and then once those issuance fees are paid, then they'll actually issue the patent, and it will be printed as a patent, just like the one that you see, or that I showed you a few moments ago. And if it's rejected, though, the examiner may say, well, I don't see it. It's not different enough. I found these other patents, which I think compare to it unfavorably. In other words, it would be obvious in light of these things. So then we have two options, well, at least two options, but the two main options are that we can uh, uh, abandon the application. We could say, well, I guess the examiner's right. Maybe it's not worthy of a patent, and then we let it go. We don't respond to the office action. The other possibility is that we respond. We submit arguments. We submit amendments. We show the patent office examiner that they're incorrect, that it is something that's worthy of a patent, that it is something that should be approved. And then sometimes what we do also is we make amendments. We see little cracks in between, and we say, okay, well, I see the patents that you're showing to me, Mr. Examiner or Mrs. Examiner, but there's also a difference in my patent application that maybe I didn't emphasize enough in the claims, like this feature. So then you flip some things around in the claims that, as I said before, the claims are the part that define what the territory is of your patent, what it is that someone else can't do to avoid infringing your patent. So maybe you need to move some things around. You make some amendments. You can only work with what's in the four corners of the patent document. You can't just add something new and say, hey, I had another idea of a new feature. If it was something that was in the patent, then there are things that we can do to shift it around and make those amendments, and then present arguments that it should now be allowable. And then again, hopefully at that point, once we submit that response to the office action, then we'll get an approval by the patent office. And if that's the case, then again, notice of allowance. The next step is to pay issuance fees, and if we do so, then the patent will be issued. I had a question before here that now fits naturally, was about maintenance fees. So with utility patents, there are maintenance fees that need to be paid after the patent issues. So 3.5, 7.5, and 11.5 years after the patent issues, there are fees that you pay to keep the patent in effect. And this is for utility patents, not design patents. But for utility patents, you need to pay those fees to keep the patent in force, meaning that keep it alive so that you could stop other people from making, using, or selling the product, stop other people from infringing. If you don't pay the fees, then the patent will expire prematurely or early, and then other people can make, use, or sell the product. And so often, though, when you hit those milestones, if you get 3.5 years after the patent was issued, either the maintenance fee is not going to be a big deal because you're doing well with the product, or you might take stock and say, well, 3.5 years have gone by, or 7.5 years have gone by since this patent issued, and I really haven't gotten anywhere with it, so maybe I'll just let it go. And by the way, if you let it go and you let the patent expire, it's not like as if you never got the patent. It's still part of the patent record. It's still there with your name on it. It's just that you can't stop other people from making, using, or selling the product. In other words, people could freely do what would otherwise have been infringement before. Now they're free to do it because the patent has not been maintained. It's not in force anymore. Okay. If you're joining us for the first time, welcome. We do this every Friday at 12 p.m. Eastern Time, 9 a.m. Pacific. You can click the link in the post to be invited to join us on the Zoom so you could then ask me anything about patents and trademarks.